Good morning, everyone. Can you hear me? Ragana, can you hear me? Can someone respond me, please? Can you hear me? Dilshani?
Yes, sir, can hear you.
Right. Okay. Thank you. We'll start. Today we are going to start with our first topic, that is type of accounts. In fact, we have three topics to discuss today. Okay, we'll take the first one. The topic is types of accounts. So these are the subtopics that we are going to discuss under this main topic. The types of accounts that we are going to discuss. Number one, individual accounts. Then we are going to discuss joint accounts. Next, corporate accounts, partnership accounts, society and associations account, administrators accounts, liquidators accounts, and minors account. Those are the types of accounts that we are going to discuss, the law applicable to these accounts. Then we'll take the first one. Under that, we'll first discuss about the individual accounts. What is an individual account? What is the law applicable for the individual accounts, and what are the documents that we need when we are opening an individual account? Individual account means a personal bank account is not for the purpose of business. This is an important point that you have to remember. You know that when we are opening, when a customer open an account, we get some information from the customer, and we ask one of the questions that we ask from the customer, for what purpose he opens the account. It is very important. It is very important to have that information. You know, there are certain law principles when we are, for example, when we are applying a combination of account, set of bankers lien, in those situations, you know that you can't combine two accounts of an individual person if those accounts are maintained in two different capacities. That means for the two different purposes. So therefore, it is very important to get this information, for what purpose the customer open the account. So if it is a personal account or individual account, rather, if, we ask the question for what purpose he use. If it is for the purpose of the private use, and if it is not for the business purpose, then that account we can categorize under the individual account. Then an individual account keep and manage their own personal funds. That is another important thing. This is their personal funds. Now you, for example, you know, I have told you this before. Certain professionals like lawyers, they can have several individual accounts, right? Several individual accounts under the individual name for different purposes. So as I explained on a previous day, a lawyer can have a personal account to manage his personal funds, and also he can have another account in the same personal name. It looks like an individual account, personal account, but the funds in that account is not the personal funds of the lawyer. Probably the funds of the customers or the clients of the lawyer. For example, the lawyer collect stamp duties and other things from the customers, and they keep those money in the account while they are paying those funds or payments to the relevant authorities. You know that nowadays, for a transfer deed, the government charge 4% of the market value. So it could be a huge amount when it comes to a deed. For now, the land price is high. If it is a western province, if it is a land in a western province, probably in 10 purchase land could value more than 10 million. So that means 400,000 stamp duty that we have to pay. So the customer normally gives that money to the lawyer. The lawyer keep that money in a basically in an account. So that account is actually not a individual personal account, because it keep the lawyer keep that account for a different purpose. So therefore, it is very important to know for what purpose that the customer maintain this account. Or otherwise, if we apply certain principles like set off and a combine of account, we'll have legal repercussions or legal the liabilities. We may have to pay damages to the customer unless we clearly got this information and keep those accounts separate. Then the individual includes when we say the person includes a natural person or artificial person or representative person. The natural persons means that a human being, a man or a woman. And artificial persons mean a legal body entity. Example, company, partnership, likewise, right? Then representative person means a person can represent another person and maintain an account. For example, a guardian can maintain an account. Administrator can maintain an account. Likewise, one person can represent the other. A trustee can maintain an account. So he's maintaining this account. It's an individual account, but is maintaining on behalf of somebody else. So when it comes to person has been defined as this: a natural person, a legal entity, or representative person. So in that case, a natural person can maintain an individual account, a company or a partnership can maintain individual account, and a representative also can maintain an account. Then the question is, when it is come to we say we take a company. Then if company open an account, individual account, then whether it's a corporate account or whether it's an individual account, the question comes. So then the difference between the individual account and corporate account, individual accounts is there to manage the personal funds. The other one, corporate account, is for the business purposes. So if a company or a partnership, if they have personal funds, that means under the business name or the company's name, maybe a profit or whatever, that funds that they can keep in an individual account, right? The purpose of the account may be for the savings or manage personal funds of that particular company or partnership. But it is not involved, that account is not involved of managing the business transactions. That is the main difference between individual account and a business account. So then we'll go to the other one, the joint account. Any questions from individual account before I go to the next one?
Yes, sir.
Yes.
Hello. Regarding this purpose of the account, say if an account is opened by a business entity, automatically the account purpose becomes a business purpose. No, so
no,
there's a contradiction.
no, it is not the case, Rangana. As I explained, a company can have two different accounts. One is for the business purpose, and other one is for is a fund management account. That means their personal money they are keeping in a savings account. For example, we say it's a we sometimes we ask them to manage route the funds in an account, savings account, as a and we ask them to, especially when we are granting facilities to corporate customers, we ask them to have a savings account to build the cash. We call them cash build-up accounts, right? So the funds, those are savings account actually, right? They are the business transaction won't happen in this account. For that business purposes, they may have another account, maybe a current account or even a savings account for the purpose of business transaction. But the other one, it's a purpose of savings of funds or managing of funds. Different is that.
So is it the duty of the bank to see whether the account is being used for business or otherwise?
Yes,
Oh,
exactly. That is why that is the duty of the bank. You know, we have a duty to get information from the customer at the point of opening the account. So two things. One is it is a duty, and other one, it is always better to have this information with the bank, because you know any transaction of the bank has to be subject to two conditions: in good faith, without negligence, right? So when you are performing your duties to prove that your action or transaction is done with good intention, good faith, and without any negligence, those information should be available with you. For example, that I gave the same example of, we say we take a we just forget about the company account, we take a individual account. So we say the individual, a natural person's individual account. This person, he has two accounts, right? So he maintain one account for his to manage his personal funds, the other one to manage his professional money, professional the income or whatever. So then if we combine these two accounts, these accounts, even though those accounts are maintained by the same person in the same bank, they are maintaining into capacities. So the combination is illegal then. So therefore, we have to be aware, and we have to take those information, and it is a duty of the bank to get that information when we open an account of a customer. At the same time, it is a requirement as per the guideline given by the central bank. Is that clear, Rangana?
yes.
Right. Any other questions from individual accounts? Okay, right. So then we'll go to the next one, interesting one, about the joint accounts. Now, joint account means an account shared by two or more individuals, right? Two or more individuals. Now, when we say the individuals means it could be a natural person, right? Two or more individuals may share one account. This is when it comes to joint accounts. It's not like a savings account. Joint account, it is coupled with certain law principles. So therefore, we have to be very careful when we are opening or when we allow individuals to open joint accounts, right? So how to operate the account? What happens if one dies? Likewise, there are law principles apply. So we should be aware those law principles when we operate and when we open a joint account. So joint account is a shared account shared by two or more individuals. Then the next important point, legal point or legal principle, is joint account holders have equal access to the funds. This is one legal principle that you have to remember. Now for the understanding, we take joint account with two individuals, right? It's easy now, right? We'll take that example: two individuals maintaining a joint account. We say husband and wife, right? The question is, we say now there is 100 1,000 rupees in this account. Question is, what is the component, or what is the percentage one individual owns rather, right? Or how much one individual can withdraw from this account? The question is that. Now, I have observed, and sometimes I have heard even our bank officers say it's 50% of each joint account holder. If there are two joint account holders, one owns only 50% of the money in the account. The case is not like that. The legal principle is joint account holders have equal access to the funds unless there is a contradictory agreement. There can be a contradictory agreement between the individuals saying that what A and B, A owns only 25%, the other one owns 75%, or they can have an agreement to say each one owns only 50% of the account. Likewise, they can have their own arrangement, but unless that agreement is there, unless there is that instruction is given to the bank, the legal principle is, in the absence of such agreement, the principle is one joint account holder owns the entire money of the account. So basically, if A and B are maintaining two accounts, joint account, A can withdraw the entire money, and also B has the same access, equal access, and if B wants, B can withdraw the entire amount in the account. So basically, they both equally have the access to the funds in the account. That is one principle that we have to remember. Then, share equal responsibility for any fees or charges incurred. The other important point is they are also equally liable for the fees and charges, including interest and overdue amounts. So that means, in other words, joint account holders are jointly and severally liable for the dues to the bank on such account. They are jointly and severally liable for the charges, interest, and overdues. So that means, if there are two or more joint account holders, bank can either file or rather demand the money from all the account, all the joint account holders, or the bank can demand the total amount from one or more joint account holders. That option is available. So you don't want to go behind all the joint account holders. You can choose one or two account holders. If you can't find the other joint account holders, you can choose one joint account holder who are in contact with the bank and claim the total dues of the account. So basically, it's a joint and several liability. Then operation of the account. Next one, and if it is a joint account, how could it operate? The operation of account may require the signature of all parties or just one. So you know that when we are opening the account, we take operation instructions from the joint account holder. It could be either party operation instruction or all parties operation instruction. Or they can, if there are more than two joint account holders, they can give separate instruction. They can say so and so have to sign the documents or the checks or whatever. The operation instructions can be given like this, given like that. So that's important thing. The operation instruction that we have to obtain in writing, and also the bank has a duty to obey the operation instructions. Or otherwise, what will happen? Whatever the instruction with contradict to the given operation instructions will be null and void, and if bank has acted on such void instructions, such a transaction will be illegal, then the bank has to return that money to the account. So that is another important point that we have to remember when it comes to joint accounts. Then next one is principle of survivorship. This is another important point that we have to remember. In a joint account, if there is no nomination given, the principle applies if one joint account holder dies, the money will go to the surviving joint account holder. For example, we say there is a joint account held by A and B, right? We say there is 100,000 rupees in the account. So A dies, then what will happen? As per the survivorship principle, so entire 100,000 rupees will go to B. So that is called survivorship, unless there is a nomination. But the question is, can we give nominations for the joint accounts? That's a gray area. So certain principles say that if there is a contradicting agreement, for example, if agreement say one person owns 50% of the money in the account, in a situation like that, that person can give nomination for this account for the 50% of the money in the account. So then the nomination will supersede the succession. So then the money will go to the nominee. However, if there is no contradicting or agreement among the joint account holder, then the survivorship principle comes into operation. So as per the survivorship principle, the entire money will go to the surviving joint account holder. So that is about the joint accounts, and the principles apply in joint accounts. Any questions from joint accounts? Rangana, you have any questions? Or Dilshani?
No, sir. No questions.
Right. Rangana, hope you also don't have questions.
Okay, sir, but is these laws are normal law applicable on these accounts, no?
You mean the law principles?
Yeah, I mean these features are considered as laws. Oh, I
Yes,
didn't get
yes,
it.
exactly. Those are laws actually. Those are principles applied and accepted by court in certain cases. Now, for example, when we say the joint account holder, he has a equal access to the money, that is established law principle accepted by court of law. So therefore, one individual account holder can claim the entire money. For example, if I have a joint account with somebody, if I have a ATM card, so I can withdraw the entire money. So the other party can't say, no, you can't withdraw all the money, and the bank is not supposed to give entire money to the other party, other joint account holder, because the law principle is that every joint account holder has the equal access to the entire amount. So the bank has no liability if one joint account holder withdraw the entire money, unless a contradicting agreement or contradicting instruction is given. So that is a principle. So basically, though these the principles that I discuss here are accepted laws of the country and also worldwide. So I believe Rangana,
Yeah,
you are okay. Right. So then we'll go to the next one. Corporate bank accounts. Next, we are going to discuss about the corporate bank account. A bank account used only for the business transaction. This is the difference between the individual accounts and a corporate account. You see, it's a narrow, very narrow definition, right? You see, in the individual account, it says the personal account for the managing of personal money, individual personal money, right? When it comes to a corporate account, it's a bank account used only for the business transaction. So that is why we say it is necessary to get that information from the customer at the point of opening the account. So you have to ask the question, for what purpose this account is open. So if customer say this is for my business transaction, so then it is a corporate bank account. So in other words, if a customer, for example, we say a company, right? Company open a savings account and say this is only this is to manage the funds of the company, not for the business purpose. So then it is an individual account. So it's, you see, it's a very narrow interpretation in the or difference between these two accounts, corporate accounts and individual accounts. And opens in the name of a business is another important point. Normally, the business or corporate accounts are maintained or open under a business name, right? Under a business name. Now, for example, a man, we say Nimal Pereira, can have an individual account under Nimal Pereira's name. And also, he can have another corporate account, right, under the business name. We say he has a proprietorship. He has a proprietorship. So under the proprietorship, he can open a business account only for the business transaction. So those two accounts are two different types of accounts. Then the payment to be made and received using the business name. Whatever the money, the payment that make and receive under the business name can be routed through this account. So that is the purpose. Then operation of business bank account is similar to the personal bank account. So operation instruction you have to get from the customer. So if it is a company, you know that you have to get the instructions from the company who are the authorized signatories. So authorized signatories are the people or the persons who are authorized to operate the business account of the company. If it is a proprietorship, then the proprietor will be most of the time the operator of the account, or otherwise he can give authority to a third party to operate the account. For example, if he has an accountant, he can nominate the accountant as the operator of the account. So likewise, bank has to get that information, instructions from the entity to operate the account. Then the corporate accounts are used for investing, savings, or everyday banking purposes. So it can be used for these purposes, for the investment, right, or savings, or everyday banking purposes. The documents that we obtain, this is very important when we are opening a corporate account. What are the documents that we have to obtain? Number one, certificate of incorporation or business registration. If it is a company, that we have to get a certificate of incorporation. If it is an individual business or partnership business, proprietorship or partnership, then we get the business registration certificate. Then if it is a company, that we take the memorandum and article, memorandum and the article of association. Those documents we obtain. Then we have set of forms that they have to file. Set of forms, that form 20. If it is a company, that we obtain form 20. Likewise, there are set of forms that we have to obtain to see who are the directors of the company, and who are the secretaries likewise. So those set of forms that we ask the customer to produce. So they take certified copies of those forms from the company registrar, that is known as ROC, right? Registrars of companies. From there, they have to obtain certified copies and produce to the bank at the time of opening the account. So then thereafter, we give them the account open applications, uh, and they have to fill those and submit to the bank. And apart from that, if it is a company, it is important to get a resolution. So the company has to pass a resolution to open an account and operate the account. So board of directors of the company, before opening the account, has to pass a resolution and resolve that they are going to open an account, and which bank they are going to make the account, what type of account they are going to open. Likewise, including those information, they have to pass a resolution. So the certified copy of the resolution also we obtain at the time of opening the account. Certified in the sense it has to be certified by the company secretary. Then those are the documents that we obtain. So what are the documents? Certificate of incorporation, memorandum and article of the company, Form 20 and other Form 12 and other documents of the other forms certified by the ROC. Then the resolution we take, and then thereafter application and mandate and signature card we take, and then only that we allow the customer to operate corporate account. So that is about the corporate account. Then thereafter, when they are operating the account, if we take a company account, corporate account, then the authorized signatories will operate the account. In certain situations, there can be, the company give authority to several people with limitations. For example, if we take a current account, current corporate account, so the company can give operation instruction like this: up to 100,000, the accountant can issue checks. So over 100,000 up to 1 million, the accountant and the head of finance should sign the checks and instructions. So anything over 1 million has to be signed by the CEO. Likewise, they can have limits or thresholds in the operation instruction. So in a situation like that, it is the duty of the bank to observe the instruction, whether they have violated the given authority that we have to observe. So those, if they have exceed the authority, we call them, there's a principle that is called ultra vires. If the authority has exceeded, it is null and void, unless the company ratify such a transaction. So in other words, it's an option of the company. Company can ratify the instruction given by the company exceeding the authority. Otherwise, they can say the instructions are null and void. So therefore, the transaction is null and void. So we have to be very careful when we are operating a corporate bank account. So that's about corporate accounts. Any questions from there? Okay, so then we'll go to the next one. Then the next one is societies and associations. Societies and association. So an unincorporated society or association is not a legal entity in law. This is very important. Unincorporated society and associations is not a legal entity. So our law doesn't recognize an unincorporated society or association as a legal entity. The question is, if they are not a legal entity, whether they can maintain bank account. So the situation is like this. Some banks allow to open an account for clubs and societies. We can see there are practical situations. Some banks allow them to open an account, but some banks, they don't allow the societies and the clubs to open accounts. So even though they are not a legal entities recognized under the law, they can maintain accounts. Now, for example, we know that minors cannot enter into a contract because they don't have the capacity to enter into contracts. But they can maintain accounts through a guardian. Right? Likewise, even though these unincorporated societies, associations, clubs are not legally recognized entities or legally recognized persons, some banks have allowed them to open an account. Right? So then these accounts are used for the dues and donations, sponsorships, and other incomes and payments of the societies or the clubs. You know, there are clubs and there are societies, they maintain these accounts because they get funds from their and donations from their sponsors and sponsorship, right? So likewise, those are their income. Sometimes they get annual membership or membership fees, subscription. Likewise, they get income. So those incomes will be routed through these accounts. And also, they have payments, right? Maybe utility bills or whatever, right? Service providers bill, whatever those bills that they have to pay will be paid from these accounts. For example, we say it's a current account, then the current account the holder, the club can issue checks for the payments. So that is that's how these societies and associations and clubs open their accounts. Then what are the documents that we require when they are opening an account? A copy of article certified by the president and the secretary. Now you know that these are not incorporated societies, not registered societies. So we take a copy of the article of the club or the society, and it has to be certified by the president and the secretary of the club or the society. Number one. Number two, certified copy of the resolution passed by the committee. Right? The committee of the society or the club has to pass a resolution to open an account. So like a company, right? They have to pass a resolution. In that resolution, they have to mention that they are going to open an account in the bank. So the bank name must be there, and the type of account that they are going to open, and for what purpose the account is maintained. All those information must be included in the resolution passed by the committee. So the certified copy of the resolution passed by the committee of the society or the club must be submitted to the bank when they request to open an account. So that is number two. Number three, the minutes of the meeting at which the present office bearers were selected. Now, when it comes to a club or a society, you know, the club or the society account will be operated by the president and the secretary or treasurer, right? Basically, the office bearers will be in contact with the bank and they will operate the account. So you know that all the members of the society will not in contact with the bank, and it is not practical also. Sometimes there can be a society where they have thousands of members. From among the members, they select a president, secretary, treasury. Likewise, they select office bearers. So the office bearers are the people who will be in contact and who will be operate the account. So the one thing that we have to be sure at the time of opening the account, whether this so-called president and the secretary or whoever the office bearers are the present office bearers of this society or the club. You know, when it comes to clubs and societies, there are our experience is always there are conflicts and all with regard to the office and office bearers, right? So therefore, it is our duty as a bank. If we allow them to open an account, we have to be sure that the people who have applied for this loan are the present bearers of the office. So therefore, for that, we take the minutes, certified minutes of the meeting which the present office bearers were selected. So that is another important document that we have to obtain at the time of opening the account. Then thereafter, we have to obtain the specimen signatures of the authorized signatory. We say the account is as per the resolution passed by the society. The authority is given to the president or president and the secretary to operate the account, or the secretary and the treasurer to operate the account. So in a situation like that, so those two authorized signatory signatures must be placed in the signature cards, and we have to keep that in our custody. So those are the documents that we have to obtain if we allow the societies, clubs, and associations to open an account. So again, I'm telling, even though they are not legal entities, some banks allow them to open an account, or others, there are other banks, they don't allow the societies and clubs and associations to open accounts in their banks. So that's about societies and association accounts. Any questions from here?
So this articles certified by the president means the constitution, I suppose. You see.
Correct. Yes. Article means the constitution of the society or constitution of the club that we have to obtain, and it has to be certified by the president and the secretary of the club or the society. Yes.
And incorporate, how incorporated means to register at which?
Yeah. Yes. Now, societies, clubs, and associations can be registered as there is a registration authority. So they can register those societies. Then they are considered as legal entities. However, most of the clubs and societies and associations are not registered. So that is the danger that we have, or the risk that we have. So if it is a incorporated society, then we are somewhat safe. Then we have to be only we have to be careful about the ultra virus principles, and whether the office bearers are the correct office bearers. Those things that we have to be aware. Then there's a risk like that. But again, if it is an unincorporated society, it is not a legal entity. It will not recognize as a legal entity. So if we say, for example, if the account is overdrawn, then how do you recover the money if it is not a legal entity? To whom, against whom that we are going to file action? Those are very, very, I would say, risky areas that we have to consider when we are going to when we allow unincorporated club or society to open an account. So in a situation like that, we have to file action against all bearers, office bearers, president, vice president, and likewise all the office members that we have to name. However, you know that the office bearers can be changed time to time. So there can be a lot of difficulties in a situation like that if we allow an unincorporated society to open an account. In that case, whether it's incorporated or unincorporated, the same difficulty that we have. But when it comes to unincorporated entity, there's no chance because the law will not recognize that society or the club as a legal person. So therefore, basically you can't name them as a defendant in the case. Is that clear?
Yes, sir.
Any other questions, any other clarifications that you need?
Sir,
Yes.
according to new CDD rules, the certificate of registration is must for the societies and clubs.
Okay.
Without any registrations document, we are not going to open accounts for societies.
Okay, right. Which CDD means?
Customer due diligence rules.
Okay, that is okay, right, from the central bank. Yeah, what is your bank?
Bank of Ceylon, sir.
Okay, okay. So this CDD rules are issued, I believe, a few years back, right? Last year.
Yes, sir. Yes, sir. After the Easter Sunday attack,
Attack
they
on
issued. Yeah.
Right. Okay. So that's a good thing, right? Thank you very much bringing that into the notice. So you see now, as I told you, time to time the central bank can pass rules and regulations. Now, as he said, now after the East attack, that customer due diligence rules has come into effect. So now you say now the banks are not allowed to open an account unless the society is registered. So thank you very much. So then you have to remember that. So this now then has changed. Not the law, but regulation has changed. Right? Thank you. Any other questions? That's thank you very much again. Reminding that any other development in these societies and associations in your banks. Basically, do you allow the societies and clubs to open an account? Now, of course, you can't because unincorporated societies, as he said, now it is prohibited by the central bank. Before that, what was the?
Before that, we have been opening accounts like.
Okay. So you allowed the customers to open an account even the society is not registered, right?
Earlier we had allowed like with these documents after obtaining the documents which you mentioned on this slide,
Right.
like after that we have opened accounts.
Right. So okay. Now anyway, now it is now changed as per the central bank rule. Now it has to be a registered club or society. So that you have to remember for your exam and as well as for your performance of your job. So then we'll go to the next one. There are other types of account that we have to discuss under these types of account. Those are administrators account, liquidators accounts, and minors account. So what is administrators account? Now listen very carefully. The administrators account comes into picture when a person dies, right? Now we say we have a customer dies, and customer estate has to be then administrate in a testamentary action. When we say a testamentary action, this is very important. Listen very carefully. When we say administration of the estate of the deceased person in a testamentary case, there are two procedures. So that procedure, which procedure that we are going to apply, will be selected on one thing. That is whether the person has written a last will or not. Right? if a person has more than 4 million estate, a deceased person has estate worth more than 4 million, that is subject to testamentary action. So then if the deceased person has written a last will, then a different testamentary procedure. If there is no last will, then it's again a testamentary action, but a different procedure. Now, in a testamentary action without a last will, the court will appoint an administrator to administrate the estate of the deceased person after filing the testamentary action. In the process of testamentary action, the court will appoint a person as the administrator of the estate. If it is a testamentary case, based on a last will written by the deceased person, then the court in the testamentary procedure will appoint a probate, right? So in the first one, if there is no last will, court will issue a letters of administration and appoint an administrator. Then in a last will action, if there is a last will in that testamentary action, the court will appoint a probate holder. They will issue a letter of probate and will appoint a probate holder. Basically, probate holder's duty also to administrate the estate of the deceased person as per the last will. That is the difference. The administrator has the authority to administrate the property or the estate of the deceased person as per the succession law. Now, when it comes to succession law, in general succession, half of the property owned by the deceased person, 50%, will be go to the spouse, and the rest half% will be go into the legitimate children of the deceased person. So that is without a last will. But when there is a last will, it will be the estate will be given to the beneficiaries as per the last will. So those beneficiaries sometimes could be the outsiders, right? So the deceased person, while his lifetime, that he can give a last will and give all the properties to a third party without giving anything to the legal heirs. So that is his discretion. So in a situation like that, the probate holder has to administrate the estate and give that estate to the beneficiaries of the last will. That is the difference between the letters of administration or probate, right? However, it is the duty of the probate holder and as well as the administrator to settle the government taxes and also pay the creditors of the deceased person. So how he is going to pay the government taxes and government payments and the taxes and the debts of the deceased person. So for that purpose, he has to maintain an account. So what he has to do is he has to get the permission of the courts and sell certain assets of the deceased person and settle the dues of the deceased. For example, we say this deceased person, he has a property which is mortgaged to the bank and has obtained a loan. Now the customer is deceased. So the bank, the legal heirs, they have filed a testamentary action, letters of administration issued. Now the administrator has to administrate the estate and settle the dues of the loan. So basically, if there are no money in the accounts of the deceased person, the administrator can get, with the permission of the court, can sell the property and settle the dues to the bank. For that purpose, he has to maintain an account. For example, we say the deceased customer's property, that administrator is going to sell for 5 million rupees. And out of that 5 million, 2.5 million is due to the bank. For this transaction and for other transactions of the testamentary action, he has to maintain an account. So those type of accounts are called administrator's account. So that the administrator's accounts, when we are opening the administrator's account, we have to get the letter of administration or the letter of probate, a certified copy of the letter of administration, or letters of probate letter, and then we allow the customer, not the customer, actually the administrator or the probate holder, to open an account only for the purpose of administrating the estate of the deceased person. So that is very important. So basically at the administration, testamentary action, the administrator will get the permission from the courts, and he will inform the courts in which banks they are going to open the account, and they will bring the letters of administration and can open an account. So then whatever the transaction, if we sell the property, that money will deposited to this account, and from there he can pay the debtors and settle the debts of the deceased person. Then ultimately he has to produce a final account statement to the courts and show how he has appropriated the money that he earned from selling the properties, and the final accounts should be produced to courts, and the court has to approve the final accounts, and then the testamentary proceedings will be terminated after that. So basically, in the most of the occasions, the administrator's account and the probate holder's accounts are maintained normally in government banks like People's Bank or Bank of Ceylon or NSB. So very rarely they come to the private banks, but there's no restrictions. But since the courts are, the government institution, independent government institution, right? Basically, they prefer to have these accounts in the government banks, right? So that is about the administrator's account. Any questions from or any clarification you need from the administrator's account before I go to the liquidator account?
So who will be appointed as the administrator? Is it the lawyer or someone else?
No, not the lawyer. Definitely not the lawyer, right? When they are filing a testamentary action, basically testamentary action can be filed by the legal heirs or close relative of the deceased person. As the petitioner, they have to report that to the courts, and they have to name all the legal heirs of the deceased person as the defendant of the case. So out of these legal heirs, one can be nominated as the administrator of the estate of the deceased person, or even a third party can be nominated as a administrator, but not the lawyer. Lawyer who has filed the action cannot be nominated as the administrator. But when it comes to a probate, yes. Any questions?
So that means even a person dies with a last will, still the legal has to go to courts and do the proceedings, no?
Exactly. That is one thing that I want to tell you. Before that, when it comes to who can be appointed as administrator, when it comes to testamentary proceedings without a last will, as I told before, any legal heir or any relative of the deceased person can file action and can be nominated as the administrator. But when it comes to a last will, in the last will, they normally, in 99% of the time, the person, that is the customer, will nominate the probate holder in the last will itself. So therefore, they can nominate the lawyer also. The customer can nominate his family lawyer as the probate holder of the last will. So in a situation like that, as that same lawyer cannot file the case, someone else can file, but the lawyer can be nominated as the probate holder to administrate the estate. That normally happens. So the administrator can be anybody, any relative, or even a third party, depending on the nature of the administration or the testamentary action. For the answer that you raise, whether when there is a last will, whether it is subject to a testamentary case, simple answer is yes. This is another thing that that in general with general public and also among the bank officers, there is a misconception. They think, or general public think, when there is a last will, the legal heirs can get together and or the beneficiaries of the last will can get together and then can divide the estate of the deceased person as per the last will. It is not the case. It is again subject to a legal proceedings. So they have to file action in courts. That is a testamentary action. Then they have to produce the last will to the courts, and they have to prove the last will as a genuine last will. Unless it is proved as a genuine last will, the court will not accept the last will, and then it will go to a normal testamentary action, like a last testamentary action without a last will. So first thing that they have to prove the last will. How do you prove the last will? In the last will, we are going to discuss about the last will later in this topic. In the last will, most of the last will are executed before a lawyer with the two witnesses, right? So then the witnesses has to give evidence, and they have to establish in courts the deceased person signed the last will before in front of them, and this is a genuine last will. And the lawyer also, if necessary, has to give evidence and testify the last will, and the genuineness of the last will has to prove in courts. Then thereafter, the court will appoint the probate holder as per the nomination in the last will. So then the probate holder has to open an administrator's account and has to administrate the estate of the deceased person as per the instruction given in the last will. That is the difference. So is that clear?
Yes.
Right. So everyone, any questions on administration's account? Okay, right. So I believe now it is clear. So then I will go to the next one. That is liquidator's account. Now when it comes to liquidator's account, remember it is about, the liquidation process relates to the companies, right? Companies, the companies, they can wind up the company business, close down the company business, right? It can be a voluntary liquidation, or it can be a liquidation by creditors. Now, for example, we say there is a company and they have taken loans or has taken financial facilities from the creditors, and now their financial situation or liquidity is so risky and so low, and therefore they are not in a position to pay the creditors. In a situation like that, creditors can go to court and file a winding up case, right? There are provisions under the Companies Act to file a winding up case by the creditors. And also, if a company itself thinks, the director board of the company thinks that they can't survive in the business because their liquidity is not feasible, and they are not in a positions to pay uh, the, the debtors, or they are not par with the going concern. So in a situation like that, the company can file a winding up action in courts. That is uh, that is called voluntary winding up. However, winding up means uh, closed down process of a company. So that is again, but remember, it is again a legal process through courts that they have to wind up. So then the application, when the application is made to the courts, then the court will appoint a person called liquidator. So he's basically the person authorized by the courts to administrate the estate, the properties of the company, and settle the dues to the creditors and government and employees likewise, and basically close down the business and terminate the company by settling all the dues from the company. So for that purpose, when a liquidator is appointed by courts, there are service providers who provide these liquidation services. So one of them will be appointed by the court as the liquidator. Once the liquidator is appointed, the liquidator has to open an account for the purpose of administrating the properties of the company which is dying now, right? So then after so that the for the purpose of managing the assets and liabilities of the company. So the duty of the liquidator is to settle all the creditors, the government taxes and dues, and the employees. When it comes to liquidation process, there is a priority list of paying the dues of the company, right? Firstly, they will settle the government payments, taxes, income tax or whatever taxes to the government, to the state. That is number one priority. Then second priority will go to the employees who have has to pay compensation, EPF, ETF, that will be paid from the estate from the properties of the company. Then the next will be in line. The third priority will go to the secured creditors of the company. Secured creditors mean the creditors who have lent to the company on collaterals, especially immobile property mortgages, mobile property mortgages, shares likewise. If they are secured creditors, then they will categorize as the next in line of the priority list. So then thereafter, the non-secured creditors, and at last the shareholders will be listed. So that's how the priority list has been listed. So then it is the duty of the liquidator to see to maintain accounts and see the liabilities of the company and the assets of the company, and the liquidator has to generate money by selling the assets of the company, and then thereafter he has to pay uh, the dues of the company or the liabilities of the company as per the priority list. So then thereafter, at the end of the process, the liquidator has to give a report with final accounts to courts that how he has appropriated the funds and how he has have managed the properties of the company, assets of the company, and how he has settled the liabilities of the company. he has to give a report. Then if the report and the accounts are approved by the or by the courts, then thereafter the court can terminate the liquidation process. Then thereafter the company comes to end, company is dead. Thereafter, under that name, there will be no company in existence. So that is liquidators accounts. So any questions from liquidators account? Any questions? Okay, so I believe you have no questions from liquidators account. Then we'll go to the minors account. When it comes to minors account, when it comes to minors account, remember under the contract law, the minor is does not have the capacity to enter into a contract, right? Then under the banker-customer relationship, you remember that we discussed the banker-customer relationship is a contract, right? If you allow a person to open an account, that means you create an account, an agreement or contract, rather, legally enforceable contract. But on the one side, the bank is there, which has the capacity to enter into a contract. In the other side, the minor is there who doesn't have a capacity to enter into a contract. Then the question is how we can enter into a legally enforceable contract when the minor does not have the capacity to contract. So minors accounts, as you are aware, are maintained by through a guardian. So guardian basically, there can be two types of guardian of a minor. So law accept the parents as the natural guardians of the child. So basically, law says the father is the natural guardian of a minor child. So in other further, it says when the father is father gets a priority. However, father and mother both are natural guardians of the minor. Supreme guardian of the minor is, remember, is always the court, right? Court is the supreme guardian of the minor. Then the natural guardian is father and mother. Or there's another way that a guardian can be appointed through courts. So for that, someone can make an application to courts, and the courts can appoint a guardian for the minor. For example, we say the father and mother both have died suddenly. We say has met with an accident. Father and mother both are died. Now child is a minor, so then his legal transactions and other things cannot be now go forward because he is a minor. He cannot enter into a contract. In a situation like that, a relation of the minor child, or even there are people that the nominated there, that they, for example, police also can make an application to the courts, and the courts can appoint a suitable person as the guardian of the minor, who has to take care of the legal transaction of the minor until he attains the age of majority. So as bankers, we have to remember two things. If parents are alive, then the parents are natural guardians of the child. So therefore, they can maintain minor's account in the bank on behalf of the minors, under and on behalf of the minor's name. And also there is there can be a situation where court can appoint a guardian for the minor child. So such a guardian can also maintain a minor account on behalf of the under the name and on behalf of the minor. So that you have to remember. So if it is a natural guardian, father and mother, So what are the documents that we obtain? Basically, we have to obtain the birth certificate of the child, and we need to get a proof to show that the person who called as the father is the natural father of the the child. So basically, when we get the birth certificate, father's name is mentioned there. Then we have to check the identity of the person who called father, and if those are tally, then we know that he's the father or the mother. So then that person can be the guardian, natural guardian of the minor to open the account. So if there are no natural guardians, then the court can appoint a guardian, as I told you, in a situation like that, that we have to ask for the court order, certified copy of the court order, uh, which has appointed the person who called the guardian as the guardian of the child. So that we have to get that court order. Then we have to check the identity of the guardian, and if we are satisfied that the same person is a person has been appointed by the court as the guardian of the child, then that person can maintain a minor's account under under the name and on behalf of the minor. So basically, we allowed minors to open savings account only. As far as I understand, we don't allow the minors to open current accounts. I have never come across a situation like that. You have you ever given a chance to open a current account to minors? I don't think so. That's a number one. That and the other thing that we have to remember, other than the savings account, basically we don't give minors facilities like credit cards and credit cards, debit card, of course, that we allow. That's an additional service that we provide to the customers where he can withdraw the money, but he can't overdraw the account. So if we overdraw the account, because the reason is that then we can't go behind the minor, as you are aware, the minors are not liable to pay the dues to the bank unless those expenses or expenses that they use for the necessities of the minor. So therefore, we have to be very careful. So then we don't allow them to open a current account, so overdraw the current accounts, or we don't give them a credit card and other facilities other than the loans for education purpose. Education purpose loans, of course, we can recover under the law. So that is the facility for necessities. So contract is then valid and can be enforced against the minor. So that is about the minor's account. Any questions up to now? The types of account.
So,
Yes.
Is there a concept called competent minor?
Competent minor.
Yeah. The Bank of Ceylon has introduced a new account. A minor can open account if he or she is above 16 years of age without the consent of the guardian, and we called them as competent minors.
Okay, very good. I have not seen this in any other banks. What about Rangana? Do you have this concept in your bank?
for teenagers, of course, we are having some account, but still, parent or a guardian had to sign somewhere. If I
Yeah,
can,
yeah. That is for the minors account. But what about the minors over 16 years of age? Competent minors?
no, for even for ones who are above 16, still
You need my parents.
consent of the parent is obtained. If I can.
Right. Okay. Right. Okay. That's a new thing. Yeah, there is a concept called competent minors. It's like this, Vidura. In Sri Lanka, we are going to discuss later in nomination, right? Where it says any person over 16 years of age can be make a nomination for the accounts maintained at a bank. So in other words, it says, it indirectly says a person who is over 16 years of age can maintain an account, right? That is number one. So, however, the majority age in Sri Lanka is 18. So, up to 18, you are a minor. Now, one side it says that you can maintain account if you are over 16 and you can make a nomination. And other side it says if you are below 18, you are a minor. So, what is this 16 and 18? Between 16 and 18, they are minors, but they are competent minors. What is competent minors mean? The meaning of competent. Now, in Sri Lanka, any person who is over 16 years of age can do a job. He is not considered as a child, right? He is not considered as a child. So he is a teenager, he is a minor, but he is a competent person, competent to do a job. So that means he can have an income. And also, as per the provisions of the Civil Procedure Code, what we are going to discuss later, as per the nomination procedure, he can maintain an account also. So, taking into consideration all these things, what we can assume is a person over 16 years of age can maintain an account and can make a nomination, and also he can do a job, or he or she, and earn income. So therefore he is competent person to have an account, right? So though he is competent, he is a minor because he is not attended age of 18. So person who is over 16 years, below 18, can be categorized as a competent minor, and he basically law is allow him to open an account. But for the safe side, most of the bank, as far as I know, only you said that this is a new thing again. It's a good thing actually. The Bank of Ceylon they are doing. I have not come across a situation even with the private banks, they have not accepted this competent minor concept. Normally, the Sampath Bank is they are the they say as they always try to do certain new things. But I have not come across a situation. Even Sampath Bank has not started this. But it's good to see that the Bank of Ceylon has taken initiatives to have competent minor accounts. So the concept is that the law, it's basically it's not black and white, where clear black and white area. It's a gray area. But when you take all these concepts together, we can say the competent minor who is aged between 16 and 18 can be maintain an account alone without the consent of the parents or the guardian. Is that clear?
Another thing, this opening of minor accounts, there may be instances where other than the parent, a third party person can open a minor, say as a gift or something. So we are allowing such things. Is it okay?
You mean it is if it is a fixed deposit? Or is a savings account?
There are minor savings accounts, no, which where the minor can withdraw only after 18 years.
Yeah.
So if I want to give as a gift, sometimes we open accounts with another.
So that means not the parent. We say uncle or somebody. Somebody open an account and deposit money.
Yeah, the account will be opened in the name of the minor with his birth certificate and all, but the adult's name won't be the parents, but another person who is above 18 years can open.
Okay, so it's like this. The law, I would say it is not prohibited, but it is not safe, right? As I told you before, the natural guardian of the child is the parents, father and mother. The uncle or somebody cannot be the natural guardian unless he has been appointed by the guardian by courts. However, since these are savings account or investment, no one will challenge, right? No one will challenge. But if there is a dispute, for example, if this person, let's say for whatever the reason, one day, if we say that I am not the guardian and I want my money back, then, for example, the minor attain majority, and then thereafter, when he wants to withdraw the money, the person who deposited money can object. Now, for just a scenario that I'm telling, right? So in a situation like that, we will face a difficulty now. He is not the guardian, but we have allowed him to open an account in the name of the minor, right? And we know that the money deposited by this person, not by the minor. So then what is the situation? Then we will have a difficulty because he is not the natural guardian. However, it's very rarely that we will get a we get a situation like that. Risk is minimum when it comes to a savings or investment under the name of the minor. But definitely, if you allow the minor to obtain a loan or something, then in a situation like that, unless the account is maintained by open and maintained by the guardian, natural or appointed guardian, then we will have difficulties. Is that clear, Rangana?
Yes.
Yes. Any other questions from the types of accounts? Okay, so then we'll go to the next one. The next we are going to discuss a new topic. Actually, even though it is in the same slides, it's a new topic. Topic is agency. Agents or agency. So under these, the topics that we are going to discuss: the legal nature of agency, creation of agency, deed of power of attorney, then the relationship including the rights and duties of the principals and agent towards each other and towards third parties, and termination of agencies. Those are the topics that we are going to discuss under the main topic of agency. So agency, what is an agency? Right? When it comes to agency, there are main words that you have to remember. Number one, the main word that you have to remember, principal. In an agency relationship or agent relationship, there are two parties involved, mainly two parties. That is the principal and the agent. Principal and the agent. Who is the principal? Principal is the person who agrees expressly or by implication that another person shall be do an act for and on his or her behalf. He shall be legally bound by that act or other person. So basically, person who appoint an agent is the person who called a principal. For example, we'll take like this. Say I'm going abroad, right? So for a period of 2 years, we say for education purpose, I'm going abroad. Now I have properties in country, Sri Lanka, or I have accounts in banks, right? Or I may have cases pending in courts, likewise. So for those matters, to attend those matters and operate accounts and maintain and manage my properties, I have to appoint a person as my agent while I'm away from the country. So for that purpose, I will appoint a person. The person who's appointed will be by me will be called as the agent, and I will be the principal in this scenario. I am the person who appointed another person as my agent to work or act on behalf of me. So I am the person who has created the agency. So the person who created the agency is called principal. In Sinhala, we call it Pradhaniya, principal. So the person who has appointed as my agent is called agent, who is representing me and doing work or acts on behalf of me while I am away. Right? So he is called agent. So the agent is the person who acts on behalf of his principal and binds him in law. So basically, when I appoint a person as my agent, the agent has to act on behalf of me, and whatever that he performs as the agent under the agency, that I will be liable for that act because he has acted on the authority given by me, and he's acted as my agent and on behalf of me. So therefore, I am liable for the acts of the agent. So that is the scenario, the principle in agency. So then the authority of the agent. The authority of the agent is the act and within which he is permitted or authorized to do by his principal, and which will be by the principal. So when I'm appointing an agent, a person as my agent, I give certain authorities. So that person has to act within the authority and work as and on behalf of me. So then for those matters, those acts performed by the agent, the principal is liable. Then the types of authorities. What are the types of authorities that can be given to the agent? Some express and some imply. That is also that we have to remember when we create the agency, principal-agency relationship. The principal give authority to the agent. Some of those authorities are expressed in writing or verbally. Prakashita. So the authority is expressed. So basically we say I appoint somebody. We say Nimal, right? I appoint Nimal as my agent. So when I am appointing him, I can appoint him by a written document. We say, for example, I give him a power of attorney. So he is my agent. Power of attorney hold. In the power of attorney itself, I can mention what are the authorities or what are the acts that he can perform on behalf of me. So that is express in writing, right? Express in writing. Or I can appoint somebody as my agent. We say Nimal. I appoint Nimal as my agent, and I verbally give him authority. I say, okay, while I'm away, you have to look after my house. You have to pay my electricity bill, water bills, and you can, if you want, you can rent this house. Likewise, I give him certain authorities. That is expressed, but not in writing. So verbal, express, authority. So that is one method, express authority. Or sometimes implied authority. Implied in Sinhala we call Vyanga. I have not verbally informed him. I have not given in writing, but by implied, that I have given that authority, or I have accepted that he has that authority. The principal has accepted. For example, now I have appointed Nimal as my agent. I am in abroad. Now he is cleaning the house and all, and also he has rented a part of the house and he is collecting the rent. I am not disputing that. I know, but I don't dispute. So impliedly, I have given that authority. That means that even though that I have not verbally mentioned that, I have not written in writing given that authority to Nimal, by implication, by imply, that I have accepted that he has that authority. So it is authority given, it is an implied authority given to the agent. So what we have to remember here is important. So authority can be given expressly, that is by writing, in writing, or verbally, or it can be given impliedly, right? It can apply impliedly. The authority can be applied. So that in general, the principal will be bound by an act only if that act is within the authority. So that is very important of the agent to do on the principals on behalf, right? Now, for example, this is why it is very important. If we are acting, or if we are getting instructions from a power of attorney holder, right? You may have observed, when a power of attorney holder comes for a transaction with the bank, the legal department always asks the power of attorney a copy of the power of attorney. They check the power of attorney, they confirm the power of attorney to the business unit, whether they can utilize the power of attorney, whether the authority is given to do such a transaction, and whether the power of attorney is still in force valid. They check with the Registrar General Department. Likewise, they check certain things. Why it is? It is because of a reason. Reason is, unless the agent has that authority to do that certain transaction, such transaction will be null and void. If it is so, then the principal will not be liable for such transaction. For example, simple example, we say that I have appointed Nimal as my agent by a power of attorney, right? We say special power of attorney. In the power of attorney, I have clearly mentioned that he can maintain my immovable properties and movable properties. But I have not given the authority him to operate my accounts. So he has utilized, he has taken the power of attorney to the bank, and the power of the bank officers have not checked the power of attorney and allowed him to withdraw money from my account. So then if I come and I see that my money has taken by my agent, that is ultra virus. He has not given that authority. So in that situation, that I can claim that money from the bank, So then the bank has to return that money because that authority is not given to the agent. But if I have given the authority to the agent, then I can't dispute, because then it is within the authority and I am bound by whatever the act done by my agent. For example, we say I have given an authority to my agent to operate my account. So I believe that he will act on behalf of me and for my benefit. So he has to pay my bills. So for that, he has to withdraw money from the bank. Bills in the sense utility bills, electricity and water. So he has to withdraw money from the bank and he has to pay the bills. So, however, my agent has misused the authority and he has withdrawn the money and he has utilized that money for his behalf and he has settled his bills also. Now, once I come to the country, I see now my agent has taken money from my account. So then I can't dispute that transaction because in my power of attorney, I have given authority to my agent to operate the account. including withdrawing money. So then it is not ultra vires. So within the capacity. So therefore, I am liable. So I can't go behind the bank and claim the money. So I have to go behind the agent and recover that money from the agent. So that is the type of authorities that can be given to the agent. Any questions from this slide? So you are okay with the principal, agent, and the authority and the types of authorities? Okay, so then in that case, then I will go to the next one. How an agency can rise? How we can create an agency? So there are 4 ways that we can create an agency. Number 1, by express agreement. Number 2, by implication. Number 3, by estoppel. Number 4, by agency of necessity. These things that you have to remember how we can appoint an agency. So we'll take one by one. First one, by express agreement. Express agreement. The common way is by agreement between the principal and agent. This is the most common way creating of agency. So basically, agreement between the principal and the agent. Most of the time, if it is a commercial transaction, those appointments are in writing. For example, we say there's a manufacturing company and they appoint agents in certain parts of the country, people or persons or business as their agent. So those agency agreements are in writing. So agreement between the principal company and the agency. So basically, most commonly, those are a written contract or written agreements. But there are situations, there can be a situation, even though the transaction is commercial transaction, they have not entered into a written agreement, but they are appointed as a agent on verbal confirmation or verbal agreement. For example, small scale businessmen or the manufacturers, they appoint their agents on verbal confirmation without signing any written agreement. So however, whether it's a written agreement or whether it's a verbal agreement, it's a express agreement. Prakashita givisuma. It's a express agreement. So that is the most common way that we can appoint an agent. So agreement can be contractual or not. Contractual means, as we are aware, contractual agreements are enforceable in court of law, enforceable, and some agreements are there, they are not actually enforceable in court of law. If if it is a contractual, rules of contract law apply. So if it is a contractual agreement, then remember the law of contract apply. Rules of contract law applies. So then the capacity of contractual capacity, intention, agreement, so all these elements must be there. Or otherwise, that the contract will not legally enforceable. So it is equally valid whether the written or oral, unless the agency is of a character which requires to be in writing. So remember, if law says the agency or the agreement must be in writing, whether it's a written agreement or whether it's an oral agreement, both are equally valid in law. So basically, you can appoint an agent verbally and orally. But if law says it has to be in writing and if special procedure to follow, then it is not valid unless you have followed the prescribed procedure. For example, you can't appoint a power of attorney holder verbally. There is a procedure. It's a document that you can you have to be in writing, and there is a registration process, and to complete that procedure, then only the power of attorney is valid. Then if you are appointing an agent by way of a power of attorney, unless it is in writing and unless you have followed the procedure, the law of power of attorney, then the power of attorney is not valid. However, you can appoint an agent without a written agreement with only a oral agreement. Both are equally valid in law. So then, an express agency agreement need not to be contractual. There may be no consideration. Parties may lack of contractual capacity, but the agreement is valid. So, if it is an express agency agreement, and it is sometimes, as we said before, need not to be contractual agreement. It can be a contractual means legally enforceable contract, but there can be a situation without a legally enforceable contract. By agreement, parties can have can create an agency. So the consideration is not necessary. Parties may have lack of capacity, right? However, the agreement is valid in law. This is an exception, the situation for the contract law. Now, for example, minor can appoint an agent to work on behalf of him. So, as we are aware, the minor cannot enter into a valid contract, legally enforceable contract. But when it comes to agency law, even though the minor does not have the capacity to enter into a contract, there is a lack of capacity, the agency contract or the agreement is valid. So, appointment of agency or agent is valid. So, now when it comes to contract law, the contract is not valid unless both parties or all the parties of the contract have contractual capacity. This is an exception situation when it comes to law. It's different from the contract law. Example, minors can both principal and the agent as express agency agreement is perfectly valid as between themselves. The principal is legally bound by the acts of agent regardless of whether the relationship is contractual or not. Then the other one is, as we said, the agent can be appointed by a contractual relationship or just an agreement. However, both are legally valid, and the principal is liable or can be held liable for the acts of the agent, whether the contract between the agent and the principal is contractual relationship or just an agreement. So basically, the principal is liable and both are equally valid. So that is about the express agreement. Any questions from here? Okay, then I'll go to the next one. By implication. So the principal can appoint an agent by, or we can create an agency relationship by implication. By implication, by implied agency arise when the both principal and agents have behaved towards each other by their conduct that they have both agreed to a relationship. The context of the principal is likely to be implied where he has put another person in such position that the person could be understood to be his agent. So what happened here? There's no express agreement. There's no verbal or writing express agreement. But the principal and the agent act accepting each other as the principal and agent, right? An implied agency arises where the both principal and the agents have behaved towards each other. For example, we take a simple example. We say, I have not appointed Nimal as my agent verbally or in writing. Verbally or in writing, I have not appointed him, Nimal, as my agent. But Nimal think that I am his agent and he act as my agent. And I also observe that Nimal is acting like my agent, and I am not disputing that. And I also behave as accepting Nimal as my agent. Right? So between Nimal and me, we don't have an agreement, written agreement or verbal agreement. We have not discussed terms and conditions, and we have basically have not discussed whether you are basically I have not basically informed Nimal that you have been appointed as my agent, but he act as my agent, and I observe that he is acting as my agent, and I acknowledge. I don't dispute. So in a situation like that, by implication, that there is an agency created. By implication, such an appointment of agency is called agency created by implication. Agency created by implication. So, there is a case on this: Panorama Development versus Fidel's Furnishing Fabrics Limited, 1971 decided case. It is an English case where it was decided by the court that the company secretary had the implied authority to make contracts in the company's name in relation to day-to-day running of the company. So what happened here? A company secretary entered into a certain agreement with the service providers for the day-to-day functions of the company. The company knew that this secretary is entering into a contract with service providers. The company has not given authority to the secretary to do so, and has not appointed the secretary as the agent also. However, knowing the fact that the secretary is entering into a contract with the service providers as the agent of the company didn't object to that, and also company acted as accepted the secretary as the agent, and the agent also has not discussed or has not appointed by the company and has not discussed any authority with about the authority with the company, but always acted thinking that he is the agent of the company. So this so because of that, third parties believe that there is a principal agent contract between the company and the secretary. So therefore, it was decided by courts by implication. There is a principal and agency relationship between these two parties. So that is about the implication, the agency created by implication. So any questions from here? Okay, so then I'll go to the next one, by estoppel. By estoppel, also known as the agency by holding out. This arises where the principal has led another parties to believe that the person has the authority or apparent authority to represent him. Even though no agency principal relationship exists, in fact, the principal is prevented from denying the existence of the agency relationship. He is bound by the actions of his or her purported agent. Now, agency by implication and agency by estoppel is, or rather, both are looks like similar. Uh, the difference between these two is very marginal, right? It all depends on the facts of the situation that we have to decide whether it's an agency of estoppel or whether it's an agency of implication. So, however, the agency of estoppel is also creates without a written agreement or written contract between the principal and the agent. It arises where the principal has held other parties to believe that the person has the authority to represent him. So, principal basically allowed the third parties to believe that person who's acting as my agent as actually the agent of mine. Now, for example, we say like this, right? We say that I am a tuition master, right? I give tuition. I have a tuition class, right? Then in this tuition class, we say that I collect daily fees, right? I collect the daily fees at the after the starting the class. I collect the fees. So one of my student, right, in the class, basically on behalf of me collect the day fees from the student every day, right? So I start my lecturing. So while I'm doing lecturing, one of the students get up and he goes to the other students and collect the money and write down their names and bring to me, and I'll keep that money, right? Now I have not appointed him as my agent to collect the money from the class. He is doing this voluntarily without asking me or without my permission. But I am not objecting, but I allow the other students of the class to believe that he is my agent. So the other student may think, okay, that we say that he is someone, we say he's Sarat, right? The Sarat is the teacher's or the tutor's agent. So that is why he is collecting money, right? We say, now I have allowed others to believe that Mr. Sarat, the student, is my agent. So one day, Mr. Sarat has collected money from the students, and he didn't give the money to me, and he has vanished. Now he is vanished with the money, collected money. So then I asked the students, today you didn't pay me my day fees, please collect. Now the student says, no sir, that we gave the money to Sarat. Sarat collected in the morning. So we paid. So then I realized now Sarat has taken money and gone. So now I can't say, no, Sarat is not my agent. Why did you pay to him? I have never asked you to do that. You should pay me. So now you have to pay again. That is not possible because I am stopped from denying the fact that he is my agent, because that I have allowed the other people to believe him as my agent. While accepting his acts, I have allowed the other people to believe he is my agent. So therefore, such type of agency is called agency by estoppel. Now when you compare this agency by estoppel and agency by implication, it's more or less similar, very, very narrow difference between these two. Then the two conditions must be satisfied when it comes to estoppel. The principal must have made a representation to the authority as to the authority of the agent. Second one important point, the third party must have relied on the representation. Representation means I have to represent, I have verbally or by expression that has to represent or mention that he is my agent, right? Or for example, in the classroom, the first day Sarat collected the money, second day Sarat collected the money, third day Sarat didn't collect the money. I say, Sarat, can you please collect the money? So that is what I request from him. When I request that, made the request, the others in the class may think, okay, now Sarat is the agent of the tutor, so therefore he has the authority to collect. So that is a representation. So others believe that. Others believe and others act believing the fact that he is the agent and gave the money to Sarat. Sarat has misused the funds. Now I am stopped denying the fact that he is my agent. So that is called estoppel, agency created by estoppel. Any questions from there? Okay, so then I'll go to the next one. Agency of necessity. Agency of necessity is the other method of creating an agency. There is a situation where one person is deemed to act as the agent of another, even though no agreement or no consent has been given by the principal, either expressly or implication. So in certain situations, especially when an urgency situation arises, one person has to act on behalf of the other person as the agent, even though that person has not been appointed as the agent or has not given any verbal or written authority to that person. This can arise only in the emergency where it is necessary for the person to act on own initiative to protect the property or interest of the another person. Now I will explain like this, right? Now we say I have a shop, right? You know, in a rural village, I have a shop. You know, then it's a one building, continuous one building. In that building, I have a shop, one room, which I have, sorry about that. Yeah, we were discussing about the agency. Now, for example, the example that we discussed, I said that I have a shop in a building, which is which is continuous building. In the middle of the building, I have a one shop. We say now, all of suddenly, the one of the shop in a corner has got with a fire. Now the fire is spreading, right? And my tenant, who is in the middle of the building, to avoid the damage, he has damaged the other, the neighboring shop's roof. He has damaged and he has destroyed the roof, then to avoid the fire being spreading. So now I have not given authority him to do such thing, right? I have not given authority. He is my tenant only. But now emergency situation arises and he has acted on behalf of me to protect my property. even though that I have not asked to do so, and I have not given authority to do that. So then the question is, after this, the other person, the neighbor of my house, or rather the shop, can claim the damages done by my agent to his roof. So in a situation like that, I can't say that I am not liable for the damages, and he is not my tenant, is not my agent. So therefore, I am not liable. If I say so, my tenant will say, even though that he has not been appointed as the agent, he is my agent, and because there was a necessity of agency created. So therefore, I am, as the principal, is liable for the damage done by the agent. So that's a situation, the emergency situation, which requires that person to act on behalf of me to protect my property. So that type of agency is called agency of necessity. Agency of necessity. The emergency must be a genuine, and action must be a necessary action. So in a situation like that, to claim the agency of necessity, the emergency situation must be a genuine situation, actual situation. And the action taken by the so-called agent should be a necessary action. If it is unnecessary action, then I am not liable. I am not liable, and there is no agency. So implied agency of necessity between the husband and principal and wife as agent was done away with by the Matrimonial Proceedings and Property Act number 1947. So in that case, the Matrimonial Proceedings and Property Act in 1970, it has demolished it has rather cancelled the agency between the husband and wife. So therefore, wife or husband cannot be considered as a principal and agent for agency of necessity under the law. So therefore, that principle is not applied. However, if it is an emergency situation, and if necessary action is taken by a person to protect the properties of mine, in a situation like that, that person can claim the agency of necessity. That is number 4, agency of necessity. Any questions from there? Okay, so then agency by necessity, rules apply. Rule number 1, it must be practically impossible or at least impractical for the agent of necessity to contact the principal. So now, rule number 1, when we are claiming the agency of necessity, if the agent can contact the principal, if he has not contacted the principal, then he can't claim the agency, because it says, the principle number 1 says, it must be practically impossible or at least impractical to the agent of necessity to contact the principal. For example, we say, I have rented out the shop, and I am not in the country. I am in abroad. So now there is a fire. Fire erupts. Then the tenant wants to contact me, but he can't. It's impossible, right? He doesn't have my phone numbers. He can't call, so he can't wait till I contact him. It is impractical. So immediately, what he did, he demolished the roof of the other shop. So by doing that, he can stop the spreading the fire into my property. So then he has protected my property by demolishing the other person or making a damage to the other person. So then the other person will claim money from me. So in a situation like that, the agent has to prove that he is not in a position to contact the principal. Rule number 2, the action taken must be necessary and for the benefit of the principal. What is necessary is objective, as we know, right? The act of the agent has to be a necessary action, and also it should be the action should be for the benefit of the principal. Now, for example, now the action that taken by my agent to damage the roof of the next shop is a necessary action, because otherwise the fire can be spread to my property. So therefore, it looks like a action, necessary action, and also the benefit of that comes to me, to the principal. Otherwise, my property will be damaged. So therefore, in this example, it's a action is a necessary action, and also the benefit comes to the landlord. So therefore, he can claim the agency of necessity. The rule number 2 is accomplished or satisfied. Then the rule number 3, the agent must have acted bona fide, that is in good faith and in the interest of the principal. So he has to act in good faith for the benefit or the interest of the landlord. So in this matter, we say the agent, my tenant, has acted in good faith and for the interest of the landlord, to safeguard the interest of the landlord. So in a situation like that, the rule number 3 will also satisfy. If these 3 rules are satisfied, then we can say the agency of necessity is created. So that's how the agency can be created. The next one, creation of agency by power of attorney, deed of power of attorney. So when it comes to power of attorney, there are a few types of power of attorneys. That is special power of attorney, general power of attorney, local power of attorney, foreign power of attorney, and then we have to talk about the termination of power of attorney. So we'll take the first one, special power of attorney. Remember that when it comes to power of attorney, we have to create the power of attorney by following the written law. Power of attorney act and prevention of fraudulence both applies. So therefore, it is a document in writing that we have to prepare the power of attorney. The power of attorney can be prepared in 2 ways. That is a power of attorney. There are 4 types of power of attorney: special power of attorney, general power of attorney, local power of attorney, and foreign power of attorney. What is a special power of attorney? Special power of attorney is given for a specific special purpose. Once the purpose is accomplished, the purpose is completed, that power of attorney cannot use for any other work, right? It's only the given authority can be exercised. No other thing can be exercised. Okay, this is not given the authority to do that. So that is we have to remember. The special power of attorney, the principal gives certain special authority to the agent. So if we exceed that authority and if we do any transaction, then such transaction is null and void. Null and void. For example, the principal can give a special power of attorney to the power of attorney holder to sell a property. To sell a property. When we say that I have several properties, right? We say I have a property at Borella. So I give the power of attorney to a friend of mine to sell Borella property. So it's a special power of attorney. By using this power of attorney, only thing that my power of attorney can do is sell the Borella property. If he sell another property by using my power of attorney, for example, we say I have another property as Narayapet. So by using this special power of attorney, if he sell if he sold my property at Narayanpeta, that sale is null and void. It is because he has not given that authority. And we say now I have given authority by special power of attorney to sell the property, Moralla property. But he, using the special power of attorney, instead of selling the property, he has leased the property. So in that case, since he has not given the authority to do that, so the transaction, the lease agreement is null and void. So therefore, I can cancel the as the principal. I can cancel the lease agreement. So when it comes to banking, it is very important. When we get a special power of attorney, that we have to be very carefully study the power of attorney and see whether the transaction that the power of attorney is going to perform is covered under the special power of attorney. For example, we say there the customer has two accounts, savings account and a current account, and the special power of attorney very clearly says the customer has given authority to operate the savings account only. So in a situation like that, if the agent comes with the power of attorney and he wants to withdraw money from the the current account, or if he wants a checkbook to operate the current account, that is ultra vires. So that means that he has not given the authority, he has not acting within the authority. So therefore, he has not authorized to do that transaction. Such transaction are null and void. Then the bank has to return that money to the current account of the account holder. So that is about the special power of attorney. Then we'll talk about the general power of attorney. General power of attorney in Sinhala we call Samanya. Samanya power of attorney. It's Samanya attorney balapatra. So general power of attorney basically gives a general power to the agent. So basically he can do anything using the power of attorney, so except certain things. For example, if we attend to personally, if the principal has to attend a matter personally, so such an action cannot be cannot perform by the agent by using the general power of attorney. For example, if I have given a power of attorney to a friend of mine, my friend cannot use the power of attorney and marry a woman on behalf of me using the power of attorney. So that is not acceptable. That is not possible under the law, because marriage contract I have to personally enter into. So that cannot be done. And also, for example, if I have to give evidence in a court, in my personal knowledge, my power of attorney holder cannot go to courts and give evidence on behalf of me, because he doesn't have the personal knowledge of that case. For example, he can't give evidence in courts in a divorce action filed by me and give evidence in that case, because those evidence is by personal knowledge. So he doesn't have that personal knowledge. He can file action by using a general power of attorney on behalf of me, but he can't give evidence. So basically, general power of attorney can be used for any purpose other than the purposes or other than the acts that the principal, has to personally attend. So that is general power of attorney. Then local power of attorney means the principal sign the power of attorney in the territory of the country. And it can be registered in the Registrar General Department. The party, the principal who resides in the country and sign in the country, within the country. So that is called local power of attorney. The foreign power of attorney is a person who he is now in abroad. The power of attorney is signed in abroad and registered in Sri Lanka. For example, we say, I I migrated to Australia, right? We say I migrate to Australia. So I want to appoint, and now I am in Australia. So I want to appoint somebody in Sri Lanka to operate my properties. So then I can write a power of attorney. So now either I can come to Sri Lanka and sign the power of attorney in Sri Lanka. So that then it is a local power of attorney. Then the other option is I can write a power of attorney while I'm in Australia, right? So then I have to sign the power of attorney in front of the ambassador, or I can sign the power of attorney in front of a solicitor with two witnesses. Then I have to send the power of attorney to the country Sri Lanka. Then in Sri Lanka, it has to be stamped and registered. Once it is registered, the power of attorney is valid. So such a power of attorney is called foreign power of attorney. Foreign power of attorney. So that is about 4 types of power of attorney. So any questions from these types of power of attorneys? This is very important to the bankers. You may have seen these power of attorneys and you may have a lot of experience with these power of attorneys. Any questions from power of attorneys? Rangana, Vidura, any questions? Okay, no questions. Right. Then the next one, termination of power of attorney. This is also important thing that when we doing banking practices, banking transaction, we have to be sure when a customer or when a person brings a power of attorney on behalf of a customer, whether the power of attorney is still invalid. We have to check that. So basically, we have to check with the Registrar General Department and see whether the power of attorney is still valid, whether it has not been cancelled. So that one thing that we have to remember. And also we should know how to terminate or how to cancel the power of attorney. So the power of attorney cancellation also is a process. It just you can't say write on the face of the power of attorney saying cancel. It is not so. There's a process. The process is that basically we have to publish the notice in the government gazette and newspapers in 3 languages, a notice saying that you are cancelling the power of attorney. So after publishing this notices in the government gazette and the newspapers in 3 languages, then thereafter we have to submit the original power of attorney to the Registrar General Departments together with the proof of publication for the cancellation. Then the Registrar General's Department will cancel the power of attorney. So that's how we cancel the power of attorney. So that is about the power of attorneys. So any questions from the power of attorneys? Okay, since no questions, now it is 11:14. We'll have a 15 minutes break and we'll meet at 11:30. Okay. Right. We were discussing the legal nature of. We are going to discuss about the partnerships. The topics that we are going to discuss about the partnership, the legal nature of the partnership, creation and registration of partnership, and relationship, including the duties of the partners to each other and to the contracting third parties, and the partnership property and the dissolution of partnership. These are the top subtopics that we are going to discuss. So seems to be others I have not joined it. Okay, anyway, we'll proceed. Okay, the legal nature of the partnership, a firm or partnership is relationship between the persons carrying on business together with the objective of making profit. It's a partnership is a firm or a partnership relationship between the persons carrying on a business together with the objective of making profit. So the law applicable is a civil law ordinance number 5 of 1852 says the English law of partnership applies in Sri Lanka. So basically, in Sri Lanka, the partnerships are also governed by the English partnership law. Apart from that, we have several acts and enactments which governs the partnership law in the country. Those are the Partnership Law Ordinance number 21 of 1866 and Business Name Ordinance number 6 of 1918. So you see now these laws established, those are very old laws. You see the partnership business law, partnership law ordinance is enacted in 1866 and the business name ordinance number 6 is 1918. The registration requirement enable the public to know the dealings of the firms. So the registration, as per the registration of names ordinance, business names ordinance is required to register the partnership. So by registering the partnership, uh, the public will know the dealings of the firm. So what type of partnership is there, who are the partners, and what type of business they are engaged in will be will be uh, will be known to the public by registering the business partnership under the business name registration ordinance. So that is a requirement when we are uh, allowing the partnership to open an account in a bank. We require those registration certificates. Then registration under the registers of companies. So the registration of a partnership also will be done at the ROC, that is Registrar of Companies. So any changes like name or death of a partner or admission of a new partner will be informed, has to be informed to the registrar within 14 days of such registration. So the registration is required under the business name registration ordinance. The business will be registered at the registrar of companies or known as ROC. And also, if there is any changes like name change of the business or death of a partner or admission of a new partner, such change has to be informed to the registrar within 14 days. Then the partnership or firm cannot be sued by its firm name. That is an important principle of law that we have to remember. Partnership cannot be sued under its name. So basically, when we are filing action against a partnership, we have to name all the partners separately and we have to sue them separately in the same action, but under the under partner's name, not under the partnership business name. So that is important to remember. That is one legal principle that we have to remember when it comes to partnership law. So each partner each partner is each partner's liability is unlimited. So what does it mean? When we say the partner's liability is unlimited, each partner is liable for the entire dues of the of the business, jointly and severally. So that is another important thing that we have to remember. So even though they have participated for the for the for the capital of the business in the liability will not proportionate according to their investment or their participation. So liability is unlimited. So each and every partner will be liable for the entire liability. It is unlimited liability when it comes to a partnership, not like a company. Company, as we know, the shareholders and the directors, they are not that liable for the debt of the company. Company and the directors are two different entities. But here, when it comes to a partnership, it is different. The partners are liable. Each partner is bound by the action of another partner. That is another important feature of the partnership. Uh, each partner is liable for the act of the other partner. So one partner is considered as an agent of the other partner. So therefore, uh, one partner's act will be bound by the other partners if that has done under the partnership and the purview of the partnership business. So therefore, each partner is liable. So maximum number of partners that we can have in a partnership under Sri Lankan law is 20 members. So we can have up to 20 members in the partnership maximum, and the capital has to be capital exceed 1,000 rupees. Then the partnership has to be registered. That is a must. So these are conditions, the legal conditions or legal requirement that we have to meet. Maximum number of partners can be 20, and if the capital of the business exceed 1,000 rupees, so that has to be registered. So basically, in practical situation, every partnership now has to register under the business registration, business names registration ordinance, and the ROC. Because practically all partnership, if it is a business partnership, capital definitely will exceed 1,000 rupees, and also maximum number that you have to limit up to 20 members or 20 partners. So partnership can be 2 members to 20 members partnership. So those are the legal requirement of a partnership. Any questions from there? Any questions? Okay, so since there are no questions, then I'll go to the next one. The partnership. When it comes to partnership, what are the documents that we require at the opening of the partnership? So basically, we know that when there is a partnership, there is the document called a partnership agreement or partnership deed. So that is a one requirement. Some banks, they ask for the partnership agreement or partnership contract, and some banks, they don't ask for the partnership agreement. Then requirement to open an account of partnership. So whether you are going to see the partnership or partnership deed or partnership agreement, it depends on the bank. Some banks, as I told you, request those that, and others don't request, because the reason is the partnership agreement or partnership deed is an agreement among the partners. So it is the duty of the partners to abide by or follow the agreement terms of such partnership agreement. So bank is a third party. The bank has no obligations to follow the rules or the terms and conditions mentioned in the partnership agreement or the partnership deed. So therefore, some banks says that we don't want to see the partnership agreement, so it's an extra burden on us. If we take that, then we have to observe the term, whether the partners are following the terms and conditions. So therefore, we don't require the partnership agreement for the purpose of opening the account. So there are two scenarios. That is, some banks request for the partnership agreement and some are not. So that's one thing that we have to remember. Then authorized signatories and power to deal the third party. So then if we are allowing the partnership to open an account, we basically we have to get instructions from the partnership on the authorized signatory. So who is basically who are basically operating the account. That information that we have to get, and we have to see who has the power to deal with the third parties. That we have to observe, and we have to get instruction. Then there are illegal partnerships that we have to be very careful. We have to see the purpose of the partnership. It could be a business purpose, and if the purpose, if the business that mentioned in the partnership agreement, if it is an illegal business, then in a situation like that, we cannot allow the partnership to open an account in our bank because the partnership is illegal. So therefore, it is very important to observe whether they are engaged in a legal activity or illegal activity. So that is one thing that we have to remember. Then active partners and sleeping partners in this partnership business, there are two types of partners. So there are partners who actively participate in the business, and there are partners, they are just only investing money, they are not actively participating in the business. They are called sleeping partners. However, the active partners or sleeping partners both are liable for the activities of the business, partnership business, and their liability is unlimited. And then when it comes to the notice to the partnership, if a notice is given to a one partner of the partnership under the law, that is sufficient. That is considered as the notice is given to the partnership, unless that partner is involved in a fraud and or has done any fraud to the partnership. So therefore, it is not necessary to give notice to all the partners of the partnership when it comes to banking. So if we give a notice to one partner, that will be considered as a proper notice given to the partnership. So that we have to remember one important point. Then death of a partner, that is another principle or another point that we have to remember. What happened if one partner is dead or several partners are dead? In a situation like that, what happened? The estate of the deceased partner is liable for the death of the partnership. So when in a situation like that, we have to see the partnership agreement. Some agreements say that once the partner is dead, the partnership comes to end. So otherwise that can say that one partner is dead, that his how to replace that the position or the vacancy, or whether the others can continue with the partnership, taking the liability of the deceased partner. However, the partner's estate is liable because the partner is personally liable for the death of the partnership. It says the estate of the deceased partner is liable for the debt of the partnership. So if partnership has not paid the loan, then we can claim that money from the deceased partner's estate also. So the incoming partner is not liable for the previous debt. This is another important point that we have to remember. You know that the time to time partnership can add partners and remove partners. So any partner is liable for the period for the debts of the period he holds the position of partner. So, for example, we say a new partner joined today to the partnership business. He will be liable for the debts that the partnership creates after that person joined. So basically, from today's onwards, for the debts due from today onwards, the new partner also will be liable. but he will not be liable for the debts that has taken or obtained by the partnership previously before he joined. So therefore, his liability is limited only to the dues or to the liabilities of the partnership after he joining the partnership. That is another thing that we have to remember with regard to incoming partners. Then the retiring partners is liable for the debt before the retirement. That is another thing that we have to we already discussed. So if one is retiring, one is removing from the partnership, that partner is liable only for the debts that partnership obtained before his retirement. So after the retirement, whatever the debt that has obtained by the partnership, the partner is liable. So after that, he will, if the partnership continue and partnership obtain loans or dues, then the retired partner is not liable for those. So then this dissolution of partnership by court or voluntarily. The partnership can be dissolved by voluntarily, or the partners can agree and dissolve the partnership by settling the dues and then appropriating the capital. Then they can dissolve the partnership. And also, if there is a dispute or if the partnership cannot uh, exist because their liquidity is not sufficient to run the business, then the business partners or even a creditor can go to courts and get a court order to dissolve the partnership. That is how we can dissolve the partner, voluntarily dissolving, or through courts, the partnership can be dissolved. Once the partnership is dissolved, the partnership is no more there, but the liability of the partners remains until they settle the dues of the partnership. That is about the principles of principles related to the partnerships. Any questions from there? Dishani, have you any questions? Do you have any questions, Dishani?
No, sir.
Right. Okay. So then that is about the partnership. Then so we'll see the partnership accounts. What are the documents that we have to obtain when we are opening a partnership account? Documents need copy of the partnership deed. As I told you before, some banks take this, and some banks they don't want to see the partnership agreement or the partnership deed. Then second one, address proof of the partnership firm. So for that we take so the notice purposes and other purposes, we take proof of address. So second one is that. Then the identity proof of all the partners, that is important. So we have to identify the partner. So we get the identity cards or identity card copies of the partners, and or any other identification document. That is number 3. Then partnership registration certificate. If it is a registered partnership, we take the partnership registration certificate. Those are the 4 documents that basically we obtain when we are opening an account for the partnership. Then operation of a account, partnership account. Number 1, operation of partnership account is similar to a joint account. So it's like maintaining a joint account. So it can be, the operation instructions can be given. So either all the parties have to sign, or or one party can be given the authority to operate the account. It's like a joint account. So then through authorized signatory or signatories, the account will be maintained. Basically, we say we have 20 partners in the partnership. So then it is highly impractical to sign all the partners when they are issuing a check or giving instruction. So therefore, what they can do is they can authorize one or two signatories as the authorized signatory to carry out the transaction of the account, partnership account. So basically the account will be operated through authorized signatories. However, when you appoint an authorized signatory or one or two partners of the partnership to operate the account, so even though they operate the account, one or two partners, all the parties, all the partners of the partnership are liable for the acts of the other partner. So therefore, the liability is joint and several. That is about the partnership accounts. How to open an account, what are the documents required, and how to operate the partnership account. So then we'll go to companies. Under the companies law or companies accounts, we are there are some topics that we are going to discuss. That is doctrine of corporate personality, lifting of corporate veil, formation and registration of a company, memorandum and article of the association, role of the capacity of the directors, and winding up. So first we'll see the corporate personality. The English company law and the Sri Lankan company law applies in Sri Lanka. Now remember, the companies, when it comes to company law on Sri Lanka has been derived from the English company law. So basically during this British colonial period, they introduced this companies law to the country. In Europe, in this period, you know that with the revolution, technical revolution or industrial revolution, they in Europe they created a lot of companies, and some of those companies were engaged in international trade and all. But when it comes to Sri Lanka and Asian countries, mainly South Asian countries, this concept of company was a new thing. However, during this colonial period, they introduced the company's concept into the country. However, this company law was introduced to the country mainly by the British people, and therefore the English company law basically initially were applied to the laws in the country Sri Lanka, and also our company law also have been derived by following the English company law. So what we have to remember here is Sri Lankan company law is basically governed by English company law and also Sri Lankan company law. The company law is a company is a fiction and not a natural person. The second point that we have to remember, when we say the company is a fiction. There's no actual person. It's not a natural person. For example, we say, we take a simple example. We say Cargill's, right? Cargill's Limited. It's a company, right? It's a company, but it's not a natural person, and it's a fiction person. When you say the Cargill's Limited, you can't show a person, or you can show a person and say this is a Cargill's Limited. Now, for example, if it is a natural person, we say Nimal Pereira, right? So natural person, you can show a person and say this is Nimal Pereira. But when it comes to a company, you can't show a person or place and say this is Cargill's Limited, for example. Now you can show the head office of the Cargill's Limited and say, you can say this is the head office of the Cargill's Limited, but it is not the Cargill's Limited, because if you go to some other place like Morelia, then you can see there are Cargill's branches there, right? And there can be another branch in several places in the country. So then the question is, actually, who is the person Cargill's Limited? Can you show one person or one entity and say this is Cargill? No, it is not like that. So that is why we say it is a fiction. It's a fiction name. It's a fiction, and that name exists as a fiction name. So, however, it is a legal entity which is recognized under the law as a person. Then, then the companies are recognized as a legal person. That's another important thing. Companies are exceptions, and companies are recognized as a person. So, when we say that the company is a fiction, normally fictions are the fictions person will not be accepted as a person in law. However, these companies are exception. Even though the company is a fiction, the law recognize the company as a legal entity or legal person. So that means under the law, the company can be sued, and company can sue anyone under the company's name. It considered as a person. So in other words, the company can hold properties, company can exercise legal rights, they can enter into a legal contracts. Likewise, it has a legal personality. So that is an exceptional thing that we have to remember. And also, it is a separate legal entity. Why we say it is a separate legal entity? It is separate from its directors, shareholders, and employees. So the directors, employees, and the shareholders are not liable for the dues or the liabilities of the company. Company is a separate entity which can exist separately from the shareholders, directors, and employees. So that's another important thing that we have to remember when you compare that with with the partnership. It's different. Partnership, even though the partnership is a business, partnership and the partners are same. The partners are liable for the liabilities of the partnership. But when it comes to the company's liability is different from the liability of the directors. That's the main thing that we have to remember. So the company can be entered into a contract. That is one thing, because it is a legal entity, and also can maintain accounts. The company can maintain the account in a bank, and can own properties and also borrow money, because it is considered as uh, a different legal entity. So then the concept of lifting of corporate veil, I explained you before, the company and the directors are not the same. They are two different people. That corporate entity is a legal entity, and the directors or directors are natural persons. They are not the same. Their liabilities are different. However, even though I say so, there are instances where the court of law has lifted the corporate veil and has held the directors liable for uh, the liabilities of the company. This is a legal principle which is known as lifting of corporate veil. So number one, uh, here the principle is the company and the directors are two different people, and they are not their liabilities are not common. The company is a separate legal entity. Directors are and the shareholders are different people, different persons. So therefore, they are not liable for the liabilities of the company. That is the general rule, company law rule, that we have to remember. So, however, the shareholder, directors, and managers and staff are different from the company. That is another thing that we have to remember. Shareholders, directors, managers, and staffs are different. But however, in certain situations, that the bank, the court, rather, the court has decided in certain cases that directors, shareholders, sometimes the employees are liable for the liability of the company. So that most famous case is Salmon versus Salmon case. And there are other one, Guilford Motor Company versus Wood, and Joan versus Limpman. All these cases, it was decided by lifting of the corporate veil. Court decided the shareholders are the company owners, so therefore they are liable for the liabilities. We have a famous case in Sri Lanka also. Uh, in the previously also we discussed this matter under the Parate law. Uh, we discussed Samathapala Jayawardena versus HNB matter. In there, the corporate were lifted and decided the main shareholder and the managing director is liable for the debt of the company. So that they are the principle applied was lifting of corporate weight. In Salmon versus Salmon also, if I briefly explain what happened, this company is it's a family business company, and one family member holds the majority of the shares of the company, and he basically engaged in the business of the company. Day-to-day activities of the company was handled by him. He was the managing director, and others were basically silent shareholders. They were not engaged in the activities of the company. Uh, so, uh, uh, so then they obtained loans and defaulted. Then thereafter, when they so basically, when the action was filed against the company directors, they took the position that they are only directors, so therefore they are not liable for the activities of the company. However, the English court they applied the principle of lifting of corporate veil and decided that the directors or shareholders who have engaged in the business and who control the business and who got the benefit of the transaction of the company are liable for the liabilities of the company, even though the law principle says the company and the directors are two different entities. So this is an exception to that principle. So where the court can hold liable the directors, employees, shareholders of the company for the liabilities of the company by lifting the corporate veil. So that is about the corporate lifting of corporate veil. Uh, sorry. Then we go to the next one. Form and registration of a company. The Sri Lankan company law and English company law applies, as I told you before, to the Sri Lankan companies law. Before 2007, we had the Companies Act, that is Companies Act number 17 of 1982. So the company registration and company activities were governed by Act number 17 of 2082 up to 2007. In 2007, a new Companies Act came into operation. By introducing the new Companies Act, it was repealed the previous act. So therefore, 1982 Companies Act is not valid today. Then Act number 7 of 2007, New Companies Act came into operation from 2007 onwards. So the companies are registered under the Act number 7 of 2007. Now, before that, the companies were registered under Act number 17 of 1982. The registration of companies are done at the registrars of companies. You know, there's a institution called registrars of companies, that is known as ROC, that is at DR Vijayawardena Mawatha, Colombo 10. So there, all the companies in Sri Lanka has to be registered under the Companies Act in this place. So the documents that we require in a company for the registration purpose and for other activities, number one is the memorandum of incorporation. So then the article of association, declaration of companies by an attorney at law, statement of registered office, and list of persons, directors and secretaries, consent of the directors and secretaries. These are the documents that we required for the registration. So basically, memorandum of incorporation means a memorandum is the constitution of the company. So the article are the rules and regulations, or in how the internal operations be done. That is the articles of association. Those two is important together with the declaration of compliance by an attorney, and also statement of registered office, list of persons, and that is directors and secretaries names must be mentioned, and the consent of the directors and the secretaries to be presented for the registration of companies. So that is about the registration of a company. Then role and capacity of the directors of a company. Shareholders means the owners of the company. We know that the company is a legal entity and it is owned by the shareholders. Shareholders participate for the capital investment, and they are investing money, and for their investment, the business or the company will issue shares to the shareholders. So basically, they are the owners of the company. The directors are the board, a bunch of people selected to manage the company, the company. So basically, they are most of the time they are shareholders also. Shareholder directors, they can selected from among the shareholders, and they are basically managing the company. Owners are shareholders, directors are the managers or the managing partners of the company. Then the directors are elected by the shareholders. From the shareholders, directors are selected. Directors appoint other staff of the company. Now, director board is there to take decisions, strategical decisions of the company. They held the board meetings, and at the board meetings they take decisions, and those decisions has to be executed by the other staff of the company. For that, the director board will appoint the main positions of the company, like managing director or CEO, chief executive officer. Such positions will be decided or will be appointed by the director board of the company. Then the directors are also considered as the trustees and agent of the company. That is another important point that we have to remember. Directors are considered as trustees, agent, or the managing partners of the company. We have a case here, Percival versus Wright. In that matter, it was decided directors are trustees of the company, but not trustees of the individual shareholders. Directors have fiduciary duty to exercise care and skill, and prohibition of company loan to directors. So the company directors cannot get loans from the company. So because they have a fiduciary relationship and fiduciary duty towards the company, so therefore they are considered as a trustees and agent of the company. So trustees cannot get the benefit from the trust. That is the principle applies here. Then winding up process. When it comes to a company winding up, company can wind up by two ways. That is voluntarily winding up or winding up by through courts. Voluntary winding up when the company is insolvent. That means if the company cannot exist because they are financially not sound, or their liabilities are higher than their assets. They are not in the positions to pay the creditors. Or when we consider the going concern, it is not feasible to exist in the business. So they are in a situation like that. The company can go for a winding up, to wind up the company. So it could be a voluntary winding up by the shareholders uh, or even creditors can file action in course to wind up the company. So winding up is a court process where you have to wind up file a case in by winding up a case in court of law. So that can be filed by any creditor of the of the company, or even the company also can file an action to wind up a case in court of law. So then after filing a winding up case, the court will appoint a person called liquidator. So liquidator is a third party who is who will be appointed by the courts to manage the assets and liabilities of the company, and pay the liabilities of the company by utilizing the assets of the company, and ultimately wind up the company by settling all the dues and closing down the business of the company. That is his duty as a liquidator. So then uh, the entire winding up process will be supervised by the court of law. So under the supervision of the court, only the winding up procedure will be proceed. So as I told before, in the winding up process, the creditors can claim their money. Not only the creditors in the winding up process, the liabilities of the company has to be settled. So when we say the liabilities, there is a priority list in the liabilities: the government taxes, employees, EPF and ETF, then the secured creditors, after that unsecured creditors, and ultimately the owners, shareholders will be paid accordingly. So if assets are not sufficient to pay the liabilities of all the parties, then some occasions that the liquidator can pay proportionately to the creditors and others of the company, if assets are not sufficient to pay the debts. Then opening an company account. When we are opening an company accounts, what are the documents that we have to obtain? Firstly, the company has to pass a resolution by the board of directors of the company, authorizing the company to open an account in a particular bank. You have to mention the name of the bank and also what type of account that they are maintaining, and for what purposes that they are maintaining the account. So those we have to get those information by way of a resolution. Then a certified copy of the resolution must be obtained. Then afterwards, we will take the business registration certificate and also Form 20 of the director's details, so on. So then thereafter, we'll get the signatures of the authorized signatories to the mandate and the loan and the signature and the authorized signatory signatures in the signature card. So then we allow the company to open an account. Then how to operate this account? So the operate of the company account will be done through the authorized signatories. So the authorized signatories can be appointed by the company to operate the account. As I told before, they can appointed with certain limitations. So therefore, we have to observe those limitations, and we have to abide by the instructions of the company. So then, closing of account also, the company authorized signatories can give instructions to close the account, and then we have to close the account. That is by the account holder, and also the bank also, if they want, they can close the account by giving a sufficient notice to the company to make alternative arrangements. So that is about the closing of account of a company. So that is about the company uh, accounts and company law. Any questions from there? Any questions? Okay, it seems to be you don't have any questions from there. So that is in the first topic that we finished today, that is types of accounts. Then we have the next one is about the dormant account, abandoned properties, nomination, last will, release of interstate properties, that we have to discuss.